So even though the number one thing in the APA Ethics Code is do no harm, you can actually violate do no harm if you are following orders. And that, this is not like brand news to Dr. Benke. People have, you know, I wrote about it, people have written about it, people have argued it. And it's sort of like, you know, very interesting. And, you know, it does nothing changes.
In the APA Ethics Code, this whole question about the contradiction between the requirement that psychologists do no harm and yet the sanction that they, or the direction that they can follow orders. And this produces a contradiction. Indeed it does. I like to think of that there are two great professions, two classic professions, basically the biomedical and the legal, that have been incorporated in the US military. And this creates an eternal and unresolvable ethical contradiction between the obligations to your profession and your clients or patients and your subordination to the chain of command, all right? What this means for lawyers, and I'll just cite two of them today, and I know others for whom this is true, including a very close personal friend of mine, that every lawyer who's a JAG faces on a daily basis the tension between these two masters, ethical responsibilities, the oath they take to defend their clients, and the oath they take as officers in the chain of command. And we've seen two examples. Lieutenant Commander Swift, who represented Hamdan, who's one of the most high profile of the JAGs, he's been denied promotion. He's being kicked out of the military. His career is over. Okay? And just this week, I think on Monday, the Sydney Morning Herald reported that Major Michael Dante Mori of the U.S. Marine Corps, who defends the man who's going to be the first person brought before the military commissions under this new law, David Hicks, an Australian detainee who's been subjected to the most strenuous regime. Mori has been recommended for prosecution by the chief prosecutor at Guantanamo, saying that his rigorous defense of Hicks has been a violation of his obligations to his commander. So again, Mori's career is over. Okay, he's out. Okay, so these are officers, and there are many officers like this who, faced with this contradiction, come down on the side of observing their ethical obligations. And so I think that I don't know, but I can't be certain, but I think psychologists, military psychologists, are in the same position. There is this constant tension. The military will press them to obey, and the professional association has to press them to obey ethical standards, okay? And then the officers themselves. But this association cannot back away. It must make its ethical requirements as clear as the military makes its requirements and insist upon them just as strenuously, and leave it to the individual officers to work out the contradictions. And hopefully in future, psychologists, and I don't doubt that there are some that we haven't heard about, that psychologists will do as Lieutenant Commander Swift, Major Mori have done, and countless other JAGs have done, is that they will mind their ethical obligations and they will pay the enormously high personal price that these officers are going to pay.
I would like to bring up the issue of the Patriot Act, which I think is an extension of what Dr. McCoy talked about, in that I think our professional organizations need to take a stand against Section 215 of the Patriot Act, which violates our confidential records, and which could very well relate to these issues, because if we have any clients who are torture victims or whatever, our records could be subpoenaed.
Just again on professional responsibility, and this is well known, but we may have forgotten, that when the Patriot Act was first drafted, who rose up professionally? A group that, and I say that we all suffer from anti-librarian prejudice, okay? But I was really surprised, and I think we were all impressed with the American Library Association rose up and fought this hard, unrestrained. You know, why? Because this goes to the core of their professional practice.
There was a group within this CPA that I was involved with, as was Michael Donner, that worked with the APA legal office to try to close the loophole in the Patriot Act that does appear on paper to permit secret subpoenas of our psychotherapy records. But our APA office and the legal office and practice director believes actually that's illegal under federal law, and but they need test cases. So if anyone gets one of these so-called national security letters for psychotherapy records, contact Billy Hinnefeld at the APA Practice Director Legal Office. She's the head of the office. They want these cases. They want to help take them to court so it can be established.
The bulk of interrogation is done by military intelligence. Most of the work that was done in Abu Ghraib and Guantanamo was done by military intelligence, not the CIA. Jane Mayer's first article in this series actually refers to the SERE technique, and it talks about, and this may not be very politically correct, but it talks about how the soldiers, in receiving their training in Fort Bragg, actually received a form of, indoctrination into techniques of torture, which they then, and this, perhaps is not quite exactly the same as what Professor McCoy is talking about, perhaps closer to what you're saying, is that oftentimes the soldiers themselves, not under orders from Donald Rumsfeld or Sanchez or whatever, not even knowing FM 3452, which is the manual that describes how you do interrogation, actually, from a psychological point of view, impose things that they weren't taught. And I think in discussing this, I think it's very important to go beyond simply what the psychologists are doing, but the whole process of psychology and understanding those techniques. And I wonder if either of you could respond to the whole discussion that Mayer started in talking about SERE techniques.
On the SERE techniques, this is one of those things, I read the Jane Mayer article, and I think this is one of those shadowy realms about which we don't know very much. My own sense has been that this paradigm, in fact, has a very complex, multifaceted journey. And that is once that, as Jeffrey Kay has suggested, once those records are open and we can actually study, it's going to turn to be far more complex than even that fragmentary initial sketch I've offered in my book. One of the ways it might have happened, but I'm not sure, is I think that the SERE techniques actually reverse the psychological paradigm. In other words, that once the CIA developed this method for interrogating others, the U.S. military intelligence, through their contact and ongoing relations with the CIA, learned it and kind of flipped it. So we wanted to train our soldiers so it couldn't be done to them. Our soldiers, having learned it, flipped it back and applied it to others. But it's the same kind of paradigm. And I think this paradigm has a very complex journey whose history we're only beginning to appreciate.